If you're an author and you're writing a book and you want to use some of those nostalgic Christmas characters, how do you know which ones you're allowed to use and which ones would be copyright infringement? Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
Tony, when it comes to writing our novels, when are we not allowed to use some of those classic Christmas characters inside of our stories, and how do we find out if we can use them?
So the first step is definitely going to be identifying the copyright status of a lot of the holiday characters. And I think that it helps even writing down a list of maybe some of the holiday characters that you had in mind. So obviously it's a given to talk about the big guy, Santa, right? So Santa's at the top of the list. His reindeer, maybe Rudolph in the mix, Frosty the Snowman, maybe elves. Elves are not really specific by name in a lot of the movies, but that are out there during the holiday season. But maybe just the general culture of elves is something that you want to add to that list. And then maybe you might be thinking of let's say, some holiday classics like Elf with Buddy the Elf, or you even be thinking about let's say. Since we're talking about Santa Claus, the Scott Calvin version of Santa Claus. Like if you wanted to do that based on the Santa Claus, shout out to all the OG 90s kids who enjoyed that movie. That was a classic.
Loved it.
Oh, so good. And as a lawyer, I take deep appreciation that the whole premise of the movie is surrounded based on a legal clause that has to be enforced because he read it.
Yep.
Genius. That's a credit to the Hollywood writers. Either way, all that to say, once you have compiled that list, that's when you have to be basically now in investigative mode and put your goggles on and really identify the copyright status of each of them. Because at the end of the day, what you don't want to do is use the copyright of a specific character that is still governed under copyright law. And I think where it gets a little testy and complex is understanding under which type of copyright act it's governed. So, for example, a lot of the older acts from 1909 to 1976 are going to be governed under the Copyright Act of 1909. And it basically allows for the term of copyright to be from date of publication or registration, 28 years. And then after that 28 years, you can renew again with the U.S. Copyright Office for an additional 28 years. So altogether, 56 years. And that's for an individual copyright. It's gotten kind of complex, admittedly, with corporate copyright ownership because those assets from the Copyright Act of 1909 that were normally governed under the Copyright Act of 1909 have kind of been grandfathered into the Copyright Act of 1976, which was amended in 1998 through the Sonny Bono Copyright Term Extension Act, also known as the Mickey Mouse Copyright Term Extension Act, because that was the whole premise of that amendment was because originally the Steamboat Willie version of Mickey Mouse was going to expire sometime in the early 2000s. So Disney lobbied Congress to extend the copyright term for corporate copyright a little bit longer. So why am I bringing all of this up? Because a lot of films from the 1930s, the 1940s, the 1950s, those types of films that have specific characters, though that were authentically created for that specific film or television show, those are likely still governed under copyright. And a perfect example would be something like Frosty the Snowman. Frosty was, created through the song, and then obviously we have, the stop motion cartoon that is still governed under copyright law. That's something that is not in the public domain. We have Rudolph the Red-Nosed Reindeer. Rudolph and even Clarice, his companion, those are still governed under copyright law because even though those are older, they're like from the 1960s, that still doesn't mean that the copyright has expired. Now, Santa is in the public domain. The reindeer, aside from Rudolph, are in the public domain. So if you want to write about Santa and the reindeer, that's fine. When you start invoking characters that are still covered under copyright, like Frosty, like Clarice, like Rudolph, even a lot of the newer characters that have come from iterations of holiday films like Buddy the Elf, that's when it becomes way more problematic because you're using content that is still protected under copyright law. Those characters are under the copyright of a specific corporate entity, a film studio, a media distribution entity. So if you plan on writing any sort of novel or book catered to the holiday season, be wise about using characters that will clearly be in the public domain, meaning that the character rights have essentially expired. Now, That doesn't mean that you can't use the characters like Rudolph the Red-Nosed Reindeer or Frosty the Snowman. You just have to go reach out and do proper licensing, get the proper permissions necessary if that's what you want to do. That gets into the whole world of now royalty share. I don't know if any authors out there are willing to concede to something like that, but either way, you could do that, but you have to do it the proper and kosher way. But all that to say, public domain characters in the holiday space are totally fair game. You could use that in your book. And it goes without saying that if you have any confusion or any doubt about the copyright status of any of the holiday characters that we've come to know and love, go speak to your lawyer. They will be the best person to help you identify the copyright status for a lot of these entities and help you navigate those waters as you write your next holiday novel.
And it's a good thing to keep in mind as you are writing your novels that using characters like this very much goes in alignment with writing a retelling. You have to do your research. You have to make sure it's not just something that feels like a really old thing. When we were doing our research on some of these characters for this episode, we discovered that while they feel like very old oral tradition that was passed down through the generations, they actually weren't. A lot of them were in songs that were not terribly long ago and are still under copyright protection. So doing your research is important. If you are going to research this, we have a whole playlist on writing retellings that will help guide you on the process, so make sure you are checking that out as well. And if you have further questions on what you can and cannot be doing legally on the publishing side of your career, now's the time to drop the questions. Tony's coming back for upcoming episodes. We want to keep you safe and protected. And if you are writing things like Christmas characters into your stories, which I have, and I hope you are too, they sell really well, you just have to make sure you have your own unique spin on them and you're not too terribly close to some other people's iterations of those characters. So if you want more details on this, go ahead and drop your questions down below. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called End Scene. New episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Your questions on the legal side of publishing down below. Tony's coming back for upcoming episodes, and we're dropping daily videos to help you navigate the world of publishing, from your writing to your publishing to your marketing, to make this your most profitable and most stress-free year ever.